Hello and welcome to this webinar on redundancies. I'm Isabel Buckle. I'm one of the Senior Employment Law Associate Solicitors at Law at Work and I'm based in the Aberdeen office. So as I say, today we'll be looking at redundancies, and that is redundancies where the proposed number of redundancies are less than 20. There is a separate and distinct process that would need to be followed if the number of redundancies exceeded 20, and my colleague will be looking at this process on our next webinar on collective consultation. So unfortunately, many of Law's clients are now facing or certainly considering redundancies due to the devastating impact that the coronavirus pandemic has had on their business. So as well as Law running these webinars to support our clients, we also have a range of employment law, HR and health and safety services that can help our clients and non-clients navigate their way through this very difficult time. So what are we going to consider today? Well, as I say, we're going to look at redundancies involving less than 20 employees. We're going to look at whether in the first instance there's any way to avoid a redundancy situation, so look at alternatives to redundancy. We're then going to look at what the legal definition of redundancy is and what that means in practice. We'll then consider what the components of a fair redundancy process is and any corresponding dismissal. We'll then look at how to calculate redundancy payments, and then finally, if things do go wrong anywhere along the line with the redundancy consultation process, what the legal risks are associated with any failings, and we'll consider that in further detail. So we're now going to look at alternatives to redundancy. So the first alternative we're going to look at is the job retention scheme, and as many of you will be aware and perhaps using this scheme already, this scheme was introduced by the government in March, and as a direct result of the coronavirus pandemic, the government introduced a number of measures to support businesses throughout the UK, and the job retention scheme is there to try and retain employees within the business. So what does the scheme do? In summary, it allows employers to recoup up to 80% of their employees' wages. That's got a cap of £2,500, and the scheme will run up until the end of October. However, from August onwards, the government announced a couple of weeks ago that there will be a slight change to the scheme. So at the moment, an employer cannot allow an employee to undertake any work or provide services under the job retention scheme. However, from August, the government have stated that employees will actually be able to undertake some part-time work, but in exchange for that, the employer will need to contribute a percentage of the employee's salary. The employee will still receive their 80% salary and up to this £2,500. However, the employer will need to put something towards that employee's wage. Unfortunately, we don't have the finer details of the scheme. The government have stated that those details will be released at some time prior to the end of May. So as soon as we receive those details, we'll filter those out to our clients and advise you of what that means for your business. Another alternative is negotiating with your employees to try and get a reduction to their current terms and conditions. Now, prior to any job retention scheme, this was really the go-to when businesses were looking to cut costs. So it's really to gain the agreement of the employees to have a reduction in perhaps their salary, any benefits that they may receive, and to change from potentially full-time working to part-time working. For the business to be able to do this, you have to seek the employee's agreement, because to change an employee's salary or benefits, it's a fundamental change to their terms and conditions. So if you don't seek their agreement, you could be faced with a claim later on down the line. So seek the employee's agreement, put that in writing, and to have the employee sign that they agree to those terms or reduction in those terms and conditions. The length of the variation is really dependent on the circumstances of the business. So it may be that you agree with the employee that the variation will be put in place for a period of months. However, it could just be an indefinite period of time. And when things do pick up, you can review this again and then potentially look to put the employee on the terms and conditions that they were on prior to this variation. Reducing an employee's terms and conditions can be also used alongside the job retention scheme, and if once we get the details from the government about what employers are having to contribute to an employee's wage, that might be the trigger for you to also then look at trying to negotiate this reduction with your employees. So what about recruitment freeze? Well, it's probably not a priority, recruitment at the moment, for the majority of businesses. However, if there are any advertisements out for your business looking for new recruits for a particular area of the business, perhaps put that on hold, especially if you're considering redundancies, because it may be that any of the people going to be placed at risk of redundancy could undertake one of these roles that you're currently advertising for. Likewise, it may be that you've already put out an offer of employment to a potential new employee, and what you can do there is either push back the start date. You'd need to gain the approval from the potential employee, or potentially you can retract that offer. So depending where you are in the recruitment process, you can notify this potential employee, because of the current circumstances we no longer require this role, and are retracting your offer of employment. What you may have to do in that situation is to pay any notice pay to that potential employee that is due under their contract of employment. So prior to making that retraction, to look at the contract of employment and to see what your liabilities are in respect of that. Looking at the next point, the use of agency workers and contractors. Certainly, if there's a risk that you're going to have to make people redundant, certainly look at what usage, if any, you have of agency workers and contractors, and if possible to stop using them going forward, because by doing that you may be able to retain someone in employment that was going to be placed at risk. However, depending on the area of business that the agency workers or contractors are assisting you with, you might not have an employee that can undertake their duties. However, as part of the redundancy consultation, you'll be able to explore with employees if they do have any other skill set that you're unaware of, and if there is an employee that's able to actually undertake some work that one of these agency workers or contractors have been undertaking, then certainly to stop using the agency stroke contractor and to allow the employees to undertake those services going forward. The next point we're going to look at is layoffs and short-time working. Typically, most employee contracts will have a clause within them which allows an employer to either lay them off or put them on short-time working. So a layoff is where there's no work available and the business are not able to really afford to pay the employee over a set period of time. And short-time working is where there may be some work available, but it's less than an employee would do, less than half an employee would do over an average working week. So the first point is to check whether there's a provision with the employee's contract. If there is, to negotiate with them, really to advise them, looking at the current circumstances, we just don't have the work available for you, and you would seek to get their agreement, if possible, that they will be laid off for a period of time. There is, however, a set period of time that layoffs are allowed, so you cannot put somebody or lay somebody off for more than 4 consecutive weeks or 6 weeks within a 13-week period. If you were to go in excess of that, what the employee can do is state that they believe their role is redundant and try and claim a redundancy payment. If, however, the business is starting to pick up, you can advise the employee that that's not the case, there's not a redundancy situation here, and serve them what's called a counter notice, and that has to be given to them within the 7 days of the employee notifying you that they feel they're redundant. So to notify them within 7 days that you do have work available, and that work will last at least 13 weeks, continuous weeks, within the next couple of weeks. So it's certainly a really useful provision to have within a contract. It's maybe something that once we know further details about the job retention scheme, if at the end of July there's going to be a cost implication for employers, you can then look to see whether you could lay off or put an employee on short time working. In relation to the pay for layoffs, an employee can claim, it's a nominal sum really, they can claim up to £29 per day, but that's capped at 5 days, so that's a total payment of £145. So certainly something to think about, and if you don't have a contractual provision, you can still seek the agreement from the employee, but again it would need to be documented, it would need to be agreed by the employee and certainly in writing, and that they sign to their agreement to this layoff and for a particular duration of time. Another option is sabbaticals, and a sabbatical or a career break is where an employee, they remain an employee but they take a period of leave for a set period of time, typically 6 months up to a year. They can be longer than that. Many employees want to go travelling, but with the current restrictions, obviously that's not going to be a reason why they would take a sabbatical. It may be, however, for family commitments. There's a range of reasons why an employee may want to take a sabbatical. A company can't enforce an employee to take it, but it's certainly something that could be considered as part of an alternative to a redundancy. If an employee is open to that, or they suggest it to you, the employee wouldn't get paid for the period of time that they're on this career break. However, the employer could decide to give them a nominal sum over the months that they're off, but there's certainly no obligation to do that. An employee would, however, be able to receive their holiday entitlement, and subject to the contractual provisions on that, it really depends on what holidays they would receive. So it's an option, perhaps not a popular one due to the current climate that we're in at the moment, but nonetheless it's an alternative to redundancy. Finally, for the company to consider just generally any cost-cutting measures that can be put in place which may retain some of your workforce. So with things as they currently are, a lot of employees are working from home. Employees are not having to travel to clients. So there's some potential cost savings there already. Other cost saving measures: if employees are potentially awarded discretionary bonuses, you can look at obviously either reducing those or not awarding bonuses during this period of uncertainty. Monies that you would potentially spend on staff functions. These are just some of the ideas you can look at and to hopefully be able to cut down some of those costs with the longer term aim to try and keep some of your employees in business by reducing some of those outgoings. So we're now going to look at the legal definition of redundancy. As with most aspects to an employer-employee relationship, there's some legal basis behind it, and the redundancy is no different. The legal definition of redundancy can be found under Section 139 of the Employment Rights Act 1996, and that gives 3 scenarios where there's a potential redundancy situation. The first one is ceasing or intending to cease to carry on the business for the purposes of which the employee was employed by it. So that's a business closure. So if your business is closing in its entirety, that would fall within the definition of the Act. Likewise, with the current circumstances that we're in with the coronavirus pandemic, certain industries or certain sectors, bars and restaurants and the hospitality industry, they've had to close their business, but there's a possibility that those businesses will open at some point in the hopefully not too distant future. But because their business is closed, for the purposes of Section 139, that would meet the definition of there being a redundancy situation. The second bullet point, ceasing or intending to cease to carry on that business in the place where the employee was so employed, otherwise known as a workplace closure. So if your company has 2 or more offices, it may be that you've decided actually we can function quite effectively and efficiently from one office, and you choose to close one of the other offices. So all the employees at that other office may be made redundant. However, it may be if your employees, one or more of them, has a mobility clause within their contract, you could seek to get those employees to work at the other office. This is very much dependent on the wording of the mobility clause. So what I would say here is that probably to seek legal advice on whether the mobility clause is enforceable and to what extent. But it's certainly an option if you didn't want to make all of those employees redundant at that place of work. Finally, the third bullet point, having a reduced requirement for employees to carry out work of a particular kind, or to do so at the place where the employee was employed to work, otherwise known as a reduced requirement for employees. Typically at law, this third scenario is the one that we would advise on the most. So in this situation, it's where the business just no longer requires the same number of employees for whatever reason, so reduced orders or reduced future orders. So you look to reduce the actual number of employees So in summary, if your business is faced with one of these scenarios, under section 139, your business will have met the legal definition of redundancy. So we've looked at the legal definition of redundancy, and so if the employer can demonstrate that one of the three potential redundancy scenarios applies to their circumstances, then there is a genuine redundancy situation for the purposes of the Employment Rights Act. There are, however, situations where on the face of it there may be a redundancy, but perhaps some of the employees' roles selected for redundancy are not actually redundant, and there's another underlying reason for their dismissal. So some employers may use the redundancy process to dismiss employees for one of the examples that I've listed within the slide. So if we look at capability, for example, this could be a situation where an employee who is on long-term sick leave, rather than the employer going through what may be quite a long, drawn-out capability process, they dismiss that employee for redundancy. And that's irrespective of the fact that this employee's role is still very much required within the business. So that would not be a genuine redundancy situation. Then looking at pregnancy and performance, similar to capability, if an employer was to dismiss either a pregnant employee or an employee who is just not really cutting the mustard, if that was the reason for making them redundant, again, that's not a genuine redundancy situation. And finally, outsourcing. If a company is looking to cut costs across the business, they may look to outsource some of their services, for example, payroll. So if a business has an employee solely undertaking the payroll and they decide to outsource that function, the service is still required, the company still need payroll. So that employee is not redundant. What should happen in that situation is that the employee should transfer to the new third-party provider. And in those circumstances, the TUPE regulations would apply, and it's not a redundancy situation. We're now going to look at the components of a fair redundancy process and dismissal. So step one in the process is announcing the redundancy, and the first thing I would say here is for the company to check whether there is actually any redundancy policy in place. If there is, it's more than likely that the policy will map out the steps that's got to be taken right from the outset and the announcement right through to any dismissals because of redundancy. So certainly review and see whether there is any redundancy policy in place. And likewise, is the business unionised or part of the business unionised? If it is, it's very likely that there'll be an agreement in place as to how redundancies have to be managed, so to be mindful of that. If there's no union and there's no redundancy policy, our recommendation is to circulate a written business case document to all employees. The business document, or the business case should I say, it doesn't have to be a very detailed document. It really just has to be an overview of why the company are in the position that they are and now having to be faced with cutting numbers. So, you know, that could be a reduced number of orders coming in and a reduced number of orders going forward. Various cost-cutting measures have been explored, but despite that, unfortunately, the business are now having to look at cutting employee numbers to ensure the long-term viability of the business. Also detailing in the document that those at risk of redundancy will be notified by a particular date, and if the other employees haven't heard by that date, then it's likely that they're not at risk of redundancy or something along those lines. It really doesn't have to be a very detailed document. And as I say to all employees, to send it to part of the business is, I suppose, going to make the other employees feel quite uncertain, worried about what that means for them. So if it goes out to all employees, everyone's receiving the same communication, and hopefully that prevents any uncertainty amongst certain parts of the business. Another option, and really dependent on the size of the business, it may be that you're able to have a staff meeting. Now, when I say staff meeting, in the current climate, a face-to-face meeting may not be possible, but some kind of video conferencing with the staff to really again state what the business case is for making potential redundancies, and that would be along the same lines as I'd already mentioned. With the face-to-face meeting, be it over video link, there's more opportunities for employees to ask questions, so that can be quite helpful to be able to answer some of those questions as far as you're able to at that meeting. And then in accordance really with the whether the business is unionised, to circulate the same letter to the trade union officials to notify them of any proposed redundancies. And again, that's something that would probably be detailed more specifically within any union agreement. So step 2, calling for volunteers. If it is at all possible, it is good practice to call for voluntary redundancies. And if you get a number of volunteers coming forward, that could result in the number of compulsory redundancies being reduced. What I would say, however, is to be clear within the documentation or correspondence calling for volunteers that there's absolutely no guarantee that their application will be accepted. What you don't want to be faced with is losing some of your key employees and some key skills that without them it's going to have a detrimental impact on the business. So the volunteer selected, it has to be right for the business and so that there is no detrimental impact going forward. Typically with a voluntary redundancy, there's usually an enhanced payment made to these volunteers. Now we'll look at statutory redundancy payments later on in the webinar. However, for a voluntary redundancy, there's an enhanced element to the redundancy payment. What that looks like is very much an individual choice, and it really depends on the circumstances for the volunteers coming forward. But we would certainly suggest, if possible, because these employees are getting an enhanced sum and their employment is going to terminate because of redundancy, that you consider entering into a settlement agreement, because their employment is still terminating, it's still a dismissal. So to ensure that you're not going to be faced with any potential employment tribunal claim going forward, whereby one or more of the employees try to suggest that it wasn't a fair process, by entering into that settlement agreement, that employee is waiving any right to pursue any claim against the company going forward. The final point is that the employees that are made redundant, even though it's on a voluntary basis, their numbers still have to be counted towards the overall number of redundancies across the organisation. So the redundancy process that we're looking at today involves redundancies where there's less than 20 employees. If including those employees that are made redundant even on a voluntary basis takes it over 20 or more, then there is that separate collective consultation process that has to be undertaken. So it's just really to be mindful of your numbers and not to forget that the people, even though they've come forward on a voluntary basis, their numbers still has to be incorporated into the overall redundancy count. In this slide, we're going to look at the question to bump or not to bump. And for those of you that have not heard the term bumping previously, it's a process whereby an employee whose role is at risk of redundancy is redeployed elsewhere to undertake an alternative role. They then are no longer at risk of redundancy. However, the individual that undertook that alternative role, they are then placed at risk of redundancy. Bumping can be seen as quite controversial and unfair, but it is certainly something that an employer can consider at any part of the redundancy consultation process. And likewise, employees can ask the employer to consider bumping a particular employee. So is there a legal obligation to bump? No, there isn't, but certainly as part of the redundancy process, or even at the outset of placing an employee at risk, it certainly should be a consideration. It may not be viable. However, if an employee were to raise it as part of their during part of the consultation process, the employer should certainly look into it and whether that is a viable option. So will a dismissal be fair or unfair if bumping hasn't been considered? Well, unfortunately, there isn't a definitive answer on this, and case law doesn't really help us either. All I can say really is that each case has to be looked at on its own merits, and certainly if an employee were to suggest bumping, or perhaps maybe not use the term bumping, but to suggest that another role within the business be made redundant rather than their position be made redundant, then that should certainly be considered. In quite an interesting case, an employment appeal tribunal case of Mirab and Mentor Graphics. In this case, Mr. Mirab, who was a sales director, as part of his redundancy consultation, he had suggested making an account manager role redundant as opposed to him being made redundant. He didn't specifically use the term bumping. Now, what the Employment Appeal Tribunal found is that Mentor Graphics should have asked Mr. Mirab if he would have been willing to take that account manager role, and they failed to do that. So that case was then referred back to the Employment Tribunal to decide whether on that basis there had been a fair or unfair dismissal. So I think in general that there certainly isn't a legal obligation to bump, but my advice would really to ensure best practice, and where possible to certainly consider the option of bumping in just the general considerations of alternatives to redundancy. In this slide we're going to look at the at-risk meeting. This is a meeting where the company are going to meet individually with those employees at risk of redundancy. The purpose of the meeting is to explain in as much detail as you can the business case for the proposed redundancy, and where possible answer any questions that the employee may have about the circumstances leading up to the business having to explore redundancies. At this meeting, if the employee is in a pool of employees at risk of redundancy, so say for example the company has 4 administrators, due to a downturn in work, only 2 administrators are now required going forward. So it's to explain to the employee, first of all, the pool that they have been selected from, so it's the pool of administrators, and that we no longer need 4 administrators, we need 2, and this is how we're going to get from the 4 to 2. Ordinarily that's done by a scoring matrix, so there's various criteria detailed within the matrix which scores each of the individual employees. So the one with the lowest scores will be put forward and continue with the redundancy consultation. So at this at-risk meeting, it's to explain to the employee that process, to show them the matrix that's been drafted and the selection criteria. We'll look at selection criteria in more detail in the next slide, but to show them the criteria and what their scores are at this point in time. It's to allow them to look at the scores, to look at the matrix, provide any feedback that they may have, and comment upon whether they feel that's an accurate reflection of the scoring based on their, say for example, skill set, qualifications, length of service, etc. Finally, is to explain what the process will be following the at-risk meeting. So stated to the employee that there will be a series of consultation meetings, and it's really for the purposes of trying to avoid their role being made redundant. At the meeting, you can actually arrange for a date when that first consultation meeting will be. You can advise the employee, and subject to if you have a redundancy policy in place or a union agreement, whether they can be accompanied to that first meeting. There's absolutely no legal requirement for that, but to check any company policy on redundancy to see whether that employee should be accompanied during that meeting. The at-risk meeting should also be minuted, and the employee should receive a copy of those minutes. Following the meeting, to write out to the employee with a copy of the minutes of the at-risk meeting, and also to confirm when the first consultation meeting will go ahead. Send a copy of the matrix and their scores, and as I say, confirm whether the employee will be entitled to be accompanied to that first consultation meeting by a work colleague or trade union representative. What I should say really, with the current circumstances that we're in, being able to meet with the individuals affected face to face is probably going to be quite difficult. So it's not going to jeopardise the process by having either a telephone meeting or the consultation to take place by way of video conferencing. And likewise for the employee's companion, they could potentially join via the video link or be party to the call. If it's a family member, it may be that you actually allow the employee to be accompanied by someone other than a work colleague or trade union representative, as is the norm. Looking at selection criteria, employers have to be very mindful of the selection criteria that they're putting within a matrix to score the employees and put them at risk of redundancy. So some of the criteria that should be absolutely avoided is if there's any discriminatory element to them. So just some of the examples that I've stated here. Last in, first out. It may be upon investigation that there is no disadvantage to any age group. So the risk would be is if you use that criteria, it's going to have an unfair disadvantage on younger employees. But if it's found that actually no particular age group of employees are disadvantaged, then that's one that can be used going forward. Likewise, absence records, if marking an employee on their absences would disadvantage an employee that has a long-standing health condition, such as cancer or heart disease, then if you're marking them because of absences relating to that, you're putting them at a disadvantage to those that do not have such underlying health conditions. And that same rule applies for employees that may have had a number of absences due to pregnancy. So certainly just to be mindful of the criteria you're using, and does it have any potential to be discriminatory towards some of the employees within the pool. Looking at the next bullet point, to use objective selection criteria where possible. The criteria should always be criteria where you can look back and it's measurable. So if this was ever challenged by an employment tribunal or the employee, you can look back and say, yes, we scored you this particular score and these are the reasons why. So there's just a clear paper trail of why this employee got a particular score. So it has to be objective, it has to be measurable. Subjective selection criteria can be quite hard to score against. So it may be that a business is looking to score someone on their attitude or the way they interact with clients. If you're not able to support a particular score you've given to an employee for their attitude, then if this is challenged, it could be deemed to be unfair because there's no accurate way of measuring it, and what you've given to one employee may not sort of tally up with the same process that you used for another employee. So it may be deemed to be unfair, but it's not saying you can't have subjective selection criteria. It just has to be, again, measurable, and there's some paper trail or some way of being able to look back and be able to give an explanation as to how you got to a particular score using that criteria. Another helpful tip on the last bullet point is considering whether to use two managers to actually do the scoring of the matrix for each of the employees within the pool, and that just ensures that your calculations are correct. It's a sense check. They're going through the same process that you've gone through to get to that score, and really ensuring that you haven't missed anything or incorrectly calculated the score, which later on down the line might be quite problematic if you've said to some of the employees they're no longer at risk based on their scores. However, the employees still at risk may challenge their score, and actually they're right that the score that you've given them is incorrect, and based on that recalculation they should no longer be at risk of redundancy. So by looking at a very early stage, it avoids the difficult situation that you might be faced with if the scoring was not accurate. Having looked at the selection criteria in further detail, I also felt it would be useful to look at the selection pool in a little bit more detail. So in the majority of cases, the selection pool will be obvious, and in the example that I've given earlier about the administrators, if those administrators did nothing else other than their administrative duties, that pool is very clear and there's no one else that would be incorporated within that pool. However, there may be cases where other employees are also undertaking similar roles, or their roles are interchangeable. So to look at another example, if an employer had 4 business development people all based in the same office but looking after different areas of the country, if an employer was to decide that the business development in Scotland was not doing particularly well and to make that role redundant, that employee would have an argument to say, actually, I'm actually doing a very similar role to the other business development people and they should be pooled together. Likewise, there may be someone else within the business that is, for example, doing internal sales, who, along with doing internal sales, does a high volume of work supporting the business development team. So they're spending a high percentage of their time supplementing the business development role. So there's potentially an argument there as well that they should also be pooled within the business development pool. So on the face of it, a lot of cases will be straightforward and there's a clear pool. However, there may be a requirement to look just beyond that pool, to look at other employees to see what work they're undertaking and whether there's a similar role or it's interchangeable. And if that is the case, they should also be incorporated into that selection pool. Moving on to step 4, the individual consultation process. I think the first point to state here is that the length of the consultation process from start to finish, there's no legal requirement where it's under 20 or less redundancies for it to be of a set length of time. What it does have to be is a reasonable length of time and to allow for meaningful consultation. We would recommend, if at all possible, that it's at least 14 days. However, it may be longer or shorter than that. It really depends on individual circumstances. In advance of the first consultation meeting, the employee should receive a copy of the minutes of the at-risk meeting. And if it's an employee that's been pooled with other employees, the employee should receive a copy of their matrix and corresponding score. So who are the parties that are going to be present at the meeting, albeit with current circumstances probably remotely? But first of all, the meeting should be chaired by someone at the appropriate level. Now, it may be that you do have that redundancy policy in place or a union agreement which would stipulate what level of manager that has to be. If there isn't any redundancy policy, it just has to be someone at the appropriate senior level. So, for example, it could be the employee's line manager. We would also recommend that there's a minute taker present, so that the person chairing the meeting isn't going to be distracted from what the employee is saying by also having to take minutes. So that's also very helpful. The employee obviously will be present, but it may be, and subject again to any redundancy policy you have, that the employee can be accompanied during this meeting. That would typically be a trade union representative or a work colleague. However, again, due to the current circumstances that we're in, it may be that the company would extend that further and allow for the employee to be accompanied perhaps by a family member. So what's then discussed at this first consultation meeting? Well, really, the key thing is to try and avoid the employee being made redundant. So it's looking at all ways to try and avoid that redundancy situation. So that could include looking at any alternative vacancies that you have across the whole organisation. It may be, if you're dealing with an employee at risk at a senior level and there's a vacancy for, say, a receptionist, that you don't notify the employee of that vacancy, but you should, because it's still a vacancy, it's still a way potentially to avoid a redundancy. So all vacancies should be notified to the employee, or if there's a number of vacancies, you should direct the employee where they can find the list of vacancies and they can go through the vacancies themselves and perhaps consider which are most appropriate for them. Again, during the course of the consultation meeting, it's to again go over the business case and whether there's been any developments since that last at-risk meeting. So that should be notified to the employee. It's likely during the course of the meeting that the person chairing the meeting is going to be doing most of the talking. So the employee should be encouraged to contribute to the meeting, to put forward any suggestions that they may have to avoid the redundancy situation. And if they do put forward suggestions, it may be that you can respond to them there and then. However, if that's not the case, they should be certainly considered, and responses to those suggestions be given at subsequent consultation meetings. During this meeting, you can also detail what monies will be payable to the employee if they were to be made redundant. Now, this does not mean in any way that the outcome is in any way predetermined. It's just giving them an idea, if they were to be made redundant, what monies they would receive as part of that redundancy package. Finally, at the conclusion of the meeting, you can arrange for when the next consultation meeting will take place. We would recommend really 2 to 3 days between meetings, and that would allow both you and the employee to go away and think of any other ideas to avoid the redundancy. As I say, if the employee has put forward any suggestions to avoid the redundancy situation, you have time to then go away and consider whether they are actually viable options. So that 2 to 3 day period would be sufficient to allow both parties to give some further thought to the redundancy process. So moving on to the subsequent consultation meetings. Really, this is a repeat of the process and the format of that first consultation meeting, and it's a continuation to explore ways to try and avoid the employee being made redundant. It may be after the second or potentially third consultation meeting that neither the employee or the employer are able to come up with any suggestions to avoid the redundancy situation. There may be no alternative vacancies. So at that point, a final consultation meeting can be arranged. In advance of what will potentially be deemed that last consultation meeting, a letter should be sent out to the employee in advance of that meeting, advising them that of what the consultation process has consisted of to date, so confirming if there's been any alternative vacancies that have been discussed but not suitable, also looking again at what the business case has been, highlighting any new job vacancies that have come about since that last consultation meeting, and notifying the employee that potentially at this meeting, if there's no alternative to avoiding their role being made redundant, that their employment may, during the course of that meeting, their employment may be terminated by reason of redundancy. The letter should also allow for the employee to be accompanied by a work colleague or trade union representative, or potentially in the circumstances again by a family member. So moving on to the final meeting, the process again is as really the earlier consultation meetings, and it's really to explore whether there's been any changes since that last consultation meeting, whether there's been any new vacancies. So again, trying to avoid the redundancy situation. If the employee has nothing to add and the employer has no further suggestions, during the course of that meeting, the employee's employment will terminate by reason of redundancy. If, however, the employee does have other suggestions to avoid the redundancy, and it's not something that you can respond to during the course of that meeting, then you would have to adjourn that meeting and then arrange for a further consultation, which may then again be that final meeting to go over the points that they've raised and to really ensure that all the points have been covered off. At the final meeting, if the employee's employment has terminated, you need to notify them of their right to appeal the decision and the process for doing that. You should then, at the end of that meeting, ensure that a letter is sent out to the employee confirming that their employment has terminated, the reason for that, and providing a summary of the process to date, and obviously that nothing could be identified to avoid the employee being made redundant. Again, the employee should be notified of their right to appeal, and again clarifying the process that they need to follow if they wish to exercise that right to appeal. Finally, on this slide, I want to go back a couple of points and look at the offer of suitable alternative role. As part of the consultation process, it may be that a suitable alternative role is identified for the employee. The employer has to actually offer that role up to the employee, and ideally that should be during the course of the actual consultation process. But certainly if an employee is actually working out their notice as opposed to being paid in lieu, then the offer of the employment should be made before the end of that notice period. We'll look at on the next slide of what suitable alternative employment looks like. However, if an employee were to accept a role of suitable alternative employment, they're entitled to a 4-week trial period, really to establish whether on the face of it may seem suitable, but the reality is it's not suitable alternative employment for them. Interestingly, if an employer offers up this, what they class as suitable alternative employment, and an employee unreasonably refuses that, the employee may actually forfeit their right to a redundancy payment. So what is a suitable alternative role? Well, there's numerous factors that have to be taken into account to really decide whether the role is suitable or not, and I've listed some of those there. Perhaps some of the key ones are the terms and conditions of employment. So an employee would be very keen to know that they're not going to be any worse off financially by taking up this new role. So if there's any reduction in their salary or their benefits package, it's very unlikely that that would be classed as a suitable alternative. Likewise, status, if you have a senior executive and the proposed new role is at a lower level, again, it's unlikely that that would be deemed a suitable alternative in the circumstances. Other examples that I'll just pick out, the location of the new job. This can be quite a controversial one, because if the proposed new role is only a very short distance, perhaps a mile or so from the employee's existing place of work, on the face of it, it would seem that it's only 1 mile and surely that must be a suitable alternative in the circumstances. But what you have to take into account is the individual's personal circumstances. So if this particular employee catches a bus into work, and ordinarily it's just one bus that he needs to catch to get in to work, it may be just extending his place of work now to that additional 1 mile may result in him having then to catch 2 buses. So it's very much depending on an individual's circumstances, and really understanding that to establish in the whole, is this going to be a suitable alternative role? So what's suitable for one person may not be suitable for somebody else. In the next part of the webinar, we're going to look at how to calculate a redundancy payment. For an employee to be eligible for a statutory redundancy payment, that employee has to have at least 2 years continuous service with the employer, and the amount of payment depends on their age, their length of service and salary at the date of dismissal. There's a really helpful tool which helps calculate an employee's individual redundancy payment, and I've highlighted that at the bottom of the screen in blue. So you go onto the government website, you put in the employee's age, length of service and salary, and if by magic the tool actually calculates the redundancy payment for you. But the details that I've put within the centre of this slide gives sort of a basic overview of how this calculator comes to the figure that it does. So 1.5 weeks pay for each complete year of service in which the employee was aged 41 or over at the beginning of the year in which they're made redundant. 1 week's pay for each complete year of service in which the employee was aged 22 to 40 at the beginning of the year. Half a week's pay for each complete year of service in which the employee was aged under the age of 22 for any part of the year. So that's a summary of how you get to the calculation. But as I say, there's that really helpful tool on the government website which will really help you calculate the redundancy payments, and it's especially useful if you have a number to calculate. In the last slide, we looked at the elements that are required to calculate a statutory redundancy pay, but we're going to look at one of those elements in further detail, and that is, what is a week's pay? What does that amount to in practice? That really depends on what hours the employee works, and I've listed 3 different scenarios here. So the first scenario is an employee that has normal working hours and whose pay does not vary. So this would be an example where an employee works 9 till 5, Monday to Friday, and their pay does not vary. So to calculate their weekly pay, you would get their gross annual salary and divide it by 52, and that would give you their week's pay. In the second scenario, an employee that has normal working hours but their pay varies according to the amount of work done, for example with piecework. So how do you calculate what their weekly pay is? Well, in this scenario, you have to have a reference period, and the recognised reference period to calculate a week's pay is 12 weeks. So what an employer would have to do in this scenario is to calculate over a 12-week period what is the average rate of pay for this particular employee. And likewise, the same applies in the third scenario, where an employee has no normal working hours. To calculate what their average pay is, you'd need to go back over that 12-week reference period and calculate what their average weekly pay is over that 12-week period. The weekly statutory redundancy pay is actually capped, and it's capped at a rate of £538. So if, when you undertake the calculations for your employee, their weekly pay is in excess of that, for redundancy, the statutory redundancy payment, they will only receive a calculation based on that £538. And the final point, because we have the benefit now of the furlough payment, and many businesses will look to undertake the redundancy exercise during this period of furlough. One question that we're asked quite frequently is whether the furlough payment will be taken into account for a week's pay. In summary, no, it isn't. So what you would need to do is to, when you're calculating an average of your employees' weekly pay, is to discount the furlough payment and go further back, so that you have a 12-week reference period that does not incorporate the furlough payment. In this final slide, we're going to look at what the implications are for a business if they're faced with an unfair dismissal claim. An unfair dismissal claim is brought by an employee who feels that perhaps the redundancy process wasn't followed in a fair manner, or potentially that there was no genuine redundancy here. The reason why they were dismissed was because of another reason. For example, they feel they were dismissed because of a long-standing health condition, and it's nothing to do with that proposed redundancy situation. So there's a variety of reasons why an employee can bring an unfair dismissal claim that flows from a redundancy process. Redundancy in itself is a fair reason to dismiss. However, if there's been an unfair process, an employee can certainly bring a claim of unfair dismissal. To bring that claim, an employee has to have, in the majority of circumstances, 2 years continuous service, and if they're successful in their claim, they're entitled to compensation. So what does the compensation look like? Well, there's 2 elements to compensation. There's what's known as a basic award and a compensatory award. The basic award is calculated in the same way as a statutory redundancy payment. So if the business has paid the employee that statutory redundancy payment, that employee will then not be able to recover any monies if he were to be successful at the employment tribunal. The compensatory award is different. If the employee is successful in their claim, the tribunal will look at what compensation to award them. And the way the tribunal will look at that is really to put that employee back in the financial position that they were had they not been made redundant. So if that employee, following their redundancy, has not been able to gain employment, and it's unlikely that they will gain employment for a considerable period of time, the tribunal will take that into account and make a compensatory award applicable to their personal circumstances. The compensatory award is, however, capped at currently £88,519 or 52 weeks gross pay, whichever is the lower amount. So an employee is only going to be able to claim up to a maximum of their 52 weeks gross pay. That said, if there was any element that the tribunal found that there was a discriminatory element to this employee's claim, then the tribunal can also award an uplift to that compensatory award, and that's potentially uncapped. So depending on the circumstances, depending on the severity of the alleged discrimination, a tribunal will look at that and award additional compensation where it was felt necessary. So certainly discriminatory claims can be very costly, and that's why it's really key at that early stage to go right back to the legal definition of redundancy and ensure that there is actually a genuine redundancy situation. It's not because of another reason. So either workplace closure, business closure, or a reduction in the requirement for the number of employees. So if that is the reason for dismissal and it's not related to any other what we class a protected characteristic, sort of age, race, religion, disability, then it's very unlikely that there's going to be that discriminatory element to an employee's claim. In closing, I'd like to say thank you very much for joining me on this webinar today. I hope you found it useful. I've made a note of my email address there, so if you do have any questions or queries following on from today's webinar, please do feel free to drop me an email and I'll happily respond to those. So thank you again, and I hope you all keep well.